This is Kendra Jackson v. Northwest Hardwoods. This is the motion to vacate default if the parties want to introduce themselves.
Nicole or plaintiff, excuse me, Kendra Jackson. Apologize.
Your Honor, this is Brian O'Connor, counsel for Northwest Hardwoods, and I don't know why my camera is not turning on. Let me try again.
I think it looks like it's about to go, but if not, that's okay.
Sorry.
Nope, you're fine.
Julie Kim for defendant Northwest Hardwood, Your Honor.
I'm sorry, Ms. Kim, I had a hard time hearing you. You're for Northwest Hardwoods also?
Yeah. Sure.
Okay. And who will be arguing today for Northwest Hardwoods?
I will, Your Honor. Brian O'Connor.
Okay. So I'll turn it over to you first. And if you kind of oh, there your camera's on. It's working. My biggest question, hopefully you'll address while you're telling me anything else you want me to know, is kind of this idea that it looks to me like Northwest Hardwoods elected to have someone be served in the state of Washington, and that certain agency there's proof of personal service with a specifically identifiable individual. So I'm trying to figure out where the excusable neglect would come in. So that's my big kind of overarching question for you, but happy to turn it over and let you tell me anything you want me to know.
Again, thank you, Your Honor. As the court knows, these matters to vacate a default judgment are equity in character. Obviously, that shapes a lot of what we come to you with today. Also, with the guiding principle from the state Supreme Court to, allow parties their day in court so they can be heard. CSC was the company's agent for service. There was some breakdown between CSC and the company. The company actually did not learn of this matter until May 14th, 2026, when a letter from opposing counsel with a copy of the debtor's examination order that you had signed, I believe. And there was then a separate one that came that they also received on the same day that had a copy of the final default judgment and the amount. There was a cover letter that kind of explained all of the stuff that had gone on.
Mm-hmm.
To the company's knowledge, they were unaware of the lawsuit. Obviously, we've been, kind of turning over everything we can to try to figure out what may have happened. You have a declaration from a gentleman named Todd Brune who led that investigation. They went through and also reviewed their emails, et cetera, and did not find evidence that it had come through. One of the individuals that's purportedly received a copy also gave a declaration, a gentleman named Tim Livermore, who was involved in the termination decision with Ms. Jackson. He was also involved in the, at that time, related union grievance and arbitration procedure. So he was well aware of, the goings on with Ms. Jackson, and obviously those proceedings under the collective bargaining agreement got dropped. He, as he's given you in his declaration, did not receive a copy, and candidly, if he had, this would have jumped out to him. I mean, it would not have been something that would have slipped by. And we know we've come to this, later. Certainly, and I understand it was probably done in part for strategic reasons. This process has been dragged out. The default judgment was entered in April. 13 months later, we get the examination of the judgment debtor. We come to the court with the basic message that, we think this is absolutely a defensible matter. We believe we have sound grounds to dispute these claims. Our client wants the ability to have it stay in court. I can understand that plaintiffs certainly would oppose that. I get that. But we think, in looking at the equities and balancing them, and again, with the state Supreme Court's guidance on this, that the court should vacate and allow the thing to proceed on its merits. We had also proposed to the court, if the court was to vacate, the default and the default judgment, that we would file the answer within 7 days and get the matter moving as promptly as possible. And obviously, if you have other questions, I'm happy to address them too.
No, thank you. I appreciate it. Ms. Tideman, go ahead.
Thank you, Your Honor. As the court's aware, I represent the plaintiff in this matter, and notably, we cited a laundry list of cases where defendants simply do not have the ability to obtain the remedy that they're asking this court to grant today. The default order was taken not on day 21 or immediately, but was taken 33 days after service. Service was effectuated properly. Defendants are solely responsible for setting up the process in which they obtain service and process of service, and they did so. Their own submission indicates that the company that they received service through had 3 email addresses, and that company indicated that they had forwarded it on. There were 2 other individuals that they said since have left the company, but were employed at the time that service was effectuated. We don't have declarations from either of them. We don't have any declarations from an IT manager or somebody else that would indicate that there was any sort of irregularity or issue with the emails or anything about their internal situation. But the basis for the defendant's request for this court to overturn the default judgment are governed by CR 60. And the only basis cited that had any real facts that they were attempting to argue is the mistake, inadvertence, and excusable neglect, which is all under CR 60B1. Those are time barred at 1 year. The court does not have the ability to overturn default judgments based off of mistake, inadvertence, or excusable neglect based off a CR 60B1 defense, which is what is being presented here. Defendant does attempt to make an argument, what I would guess would be to get around that 1 year time bar. And they do that under CR 60B11, but the motion does not cite any extraordinary circumstances, which is what would be required to obtain relief. The pleading just indicates the circumstances presented here and above would somehow entitle them to relief, but the only circumstances pled are mistake, inadvertence, or excusable neglect. We cited in our response that there's a case that talks about that the court can't use, or defendants can't come to the court and attempt to make an argument under 3060B11 that would then really be under 3060B1 in an attempt to circumvent the 1 year time bar that is included in that rule. There are no extraordinary events here that would allow the defendants to proceed forward and to obtain the relief that they are requesting. We have a really clear case where perhaps a defendant has a claim against the service company if they believe they do, but the reality is that they set that up. They were 100% responsible for that process. They could have picked anyone. This was the process that was selected. The email addresses were part of that agreement that this was going to be sent to, and simply because defendant did not defend or appear in this matter, we were able to take the default order and subsequently get a default judgment in this matter. The time has been extraordinary that has passed for this motion to be presented to the court. There is nothing that would get defendant around the 1 year time bar. And there is, again, even if we weren't in that circumstance, the case law is very clear that a breakdown of office procedures, mistakes made by individuals. This is not a reason that would allow this court to find excusable neglect and overturn this judgment. We'll rely largely on the case law that we cited within our response, of which there is many cases that would support that this court cannot do what defendant is requesting. And we're asking that the court deny this on its face. If the court intended for CR 60B11 to be a catch-all at any time anything happens, then we wouldn't need the rest of the rule. That would just be a catch-all at any time for any reason. If the defendant shows up and says, whoops, this happened, and now we'd like the court to overturn this. But the plaintiff deserves to have some finality. She deserves to be able to move forward. This was settled long ago, and the court should not entertain this motion to overturn the default judgment and order.
Thank you.
Thank you.
Mr. O'Connor, any rebuttal?
Briefly, the argument that it's been a long time, candidly, they made it a long time. I mean, they waited 13 months to come back and request the debtor's exam and then send that letter to my client. And again, I understand we didn't respond, so they're just going to kind of lay in wait and not do anything and do all these things, and then we find out about it. When we learned of this on May 14th, we did react promptly. The client did review processes. That's in Mr. Brune's declaration. Counsel was retained. We were retained on the 18th of May. I contacted opposing counsel the same day. We filed a notice of appearance the following. There was a court hearing on the 20th of May, which my colleague, Julie Kim, appeared at. And we filed a motion on the 26th after the holiday. So we moved as quickly as possible once we had notice of the proceedings. And again, balancing the equities. And again, we think what is a meritorious defense. We would ask the court to grant the motion to allow us to put on that defense and have this matter tried on its merits.
Okay, thank you. So here are some of the facts in my review that form the basis for my decision. I think it's undisputed that defense, and I assume plaintiff probably agrees that defense got involved in this case recently in May of 2026 after being served with the order for examination of judgment debtor, the subpoena ducis tecum. I looked at that proof of service. It went to an address at 300 Deschutes Way Southwest, Suite 208, Tumwater, that's where personal service was made, which is the Corporation Services Company address, who is the registered agent for the defendant, Northwest Hardwoods. So that personal service was done at that specific address to CSC, and it did make its way to the defendant. I think we all agree with that. So if I look backwards, then the proof of service I have for the original summons, complaint, and request for jury trial was actually signed by the same process server and was personally delivered to a specific individual named Ellen Jones to that same address, 300 Deschutes Way Southwest in Tumwater. It also, again, to CSC, and that service is dated September 11th, 2024, filed with our court September 16, 2024. So I don't see any inconsistencies in where the 2024 service was made when compared to the 2026 service that did make its way to the defense. So turning then to the rule, and I certainly understand this court sits in equity, and I on numerous occasions have vacated defaults, citing very specifically what Mr. O'Connor cites is courts prefer to have cases tried on the merits, and that is well accepted. In order for me to exercise that equity, though I do turn to the rule CR 60, it does appear to me that this motion is primarily done under CR 60 B1 for mistake or excusable neglect or inadvertence. I'll talk about subsection 11 in a minute, but if that's the case, then it does have to be within a reasonable time and not more than 1 year after judgment order proceedings were entered. So clearly, just on a time bar, it would fail. So then jumping to, let's just assume for sake of argument that subsection 11 that doesn't have the 1 year time bar also operates to allow this court to look at things like mistake and excusable neglect. As I think both parties would agree, significant case support for these exact scenarios where the Court of Appeals, appellate courts have said inter-corporation processes, those breakdowns don't qualify for as inexcusable neglect. So I would never purport to give anyone legal advice on this document. This docket, it certainly sounds like a case where the nominated service corporation did not fulfill its duties to the defendant, but that does not result in excusable neglect. In fact, it's what the courts have described as inexcusable neglect. So I'm going to deny the motion to vacate for those reasons. Do the parties need a presentation date for an order, or do you all think you can agree on how that should be worded? If we do a presentation, I'll have to set you out 2 weeks the next time I'm on this docket.
I would prefer just to set a presentation date and then hopefully we can just
Okay.
work out the terms of the order, but that way we have a backstop just in case that does not get finalized.
Would June 17th at 2 o'clock work for that presentation?
That works for me, Your Honor.
Within 1 second.
Okay.
I'm in a deposition, but I think my colleague can cover it.
Okay. And if we need to move it, then just know it would be 2 weeks after that, which I think would be July 1st. So either I'm fine if the parties agree to renote to July 1. And then how do you, Ms. Tideman, want to handle the supplemental proceedings at this time?
I did receive from defendant an objection to the subpoena, and I have not received any documents. So I would like an opportunity to discuss those objections with defense counsel, see if we can work through those. So I would like to set that to the 17th as well, so that hopefully we can work through any of the subpoena issues and obtain documents. But without documents, I don't want to proceed forward today.
Mr. O'Connor, would your associate be able to handle that matter, or would you prefer to handle it?
I have confidence in my colleague. Let's say the 17th, if it's okay, if in hindsight we reassess that, I'll talk to opposing counsel. Maybe we can push that out.
Understood.
Does that work? Okay.
Yep. So for now, I'll set you to June 17th unless we hear otherwise that you would all prefer the July 1st date.
Okay.
Okay.
Sounds good.
All right. Thank you all for your time.
Thank you.
Thank you.